Hi, so I'm going to answer for you today the top 5 questions that our clients ask regularly about divorce. So hopefully this will help give you a little bit of clarity about things that maybe you're asking yourself right now. So the first question I always get asked is, Tracy, when can I get a divorce? And so the answer is this: you have to be separated for 1 year and 1 day before you can apply to the court for a divorce. You can't make it underneath that. You can't do it for 364 days. You can't even do it for 365 days. Otherwise, the court will actually reject your application, and then you're going to have to do the whole thing over again. And that is even if you both agree. So it's really important that you make sure you count down from the day of separation, which is really important because you can be separated under one roof. The day that you start your date of separation is the day that you've had that conversation where you've said, you know what, we're done. Move out of the bedroom, the marriage is over, it's ended, all of that stuff. So just make sure you always note that in your diary, because after that time you can do it. Bear in mind, on the other extreme is you don't have to rush and get a divorce once that happens either. You can take as long as you want to apply for a divorce. There are some people I have known who have been actually separated for 20 years and then have decided to get a divorce. So that's perfectly fine. It's really important though that you make sure that you know that getting a divorce just means that you can get remarried. It doesn't actually divide your assets. That is something called property settlement. So it's really important you don't confuse the two. So the next question that I always then get asked after that is, how much does it cost? Fair enough, fair question. So we actually have, unless it's a complex divorce here, which doesn't happen that often, normally we have fixed fees for our divorces, which is $880 is what we charge, plus your outlays. So your outlays are things like your filing fees. And I'm not going to tell you how much that is right now because the court changes it on a regular basis. So it's really important that if you want to have an idea, jump onto the family court website and actually have a look at the fees, and they'll actually have them listed there for you. So I hope that gives you clarity about costs. The third question I usually get is, what happens if the other party refuses to get a divorce or won't sign the documents? The answer to that is that's fine. We're not America. You don't actually need permission from the other party in order to actually get a divorce. All you would have to do is file the application on your own, and then you have to serve them with a copy of the documents. So serving means you have to give them a copy and just swear a small little affidavit which outlines that you've actually done that and that they're on notice of the application. Once that happens, you can actually proceed with the matter. So the fourth question is, do I have to go to court? Well, this is an interesting question. So the answer is potentially yes or no. Most people do not have to go to court where they are bringing an application for a divorce. If you both do it jointly and there are no children involved, you do not have to go to the court. If you even file on your own and the other party's been served, you technically don't have to go to court if there are no children. But you do run the risk that the other party might turn up on that day and say, I object, or I don't agree with the date of separation, or I have a problem, etc. So you might get notice after the fact. But I always say, if you're not confident with it, then you don't have to. But if you do have children, then yes, you have to turn up to court. And as a rule of thumb, if you've been separated under one roof, you should always turn up to court, because the court may want to know a few extra facts from you to make sure that they are comfortable that you actually were separated. So I hope that helps in that regard. The final one is, what happens if I can't find the other party or I don't know where they are? And that actually happens a lot. So if that does happen, then that's where you may actually need the assistance of a lawyer, or at least some form of help. But what we do is actually we go for something called substituted service. So if I can't find out where someone is physically located, But if I have their email address or I have their phone number or I have their Facebook account, then what I will do is send off emails letting them know, heads up, I have an application and this is the date and this is what I'm going for. And if I can attach the documents and get a copy of the documents through that way, I will. Alternatively, I will also go through their families, or I will hire a private investigator to actually find them, or do an electoral roll search. So if you can do that, then great. Then what you do is you go into the courtroom and you make an application for substituted service that basically the court will deem that they have been given a copy or they're aware of the proceedings. And it might take a couple of goes for you to turn up to court, but that's what you would have to do. So there are always ways around it that you can actually get it done. So I hope that's actually helped. And those are the top 5 things that people ask all the time. And if you've got any other questions, then just reach out and have a chat with us and we'll be able to answer them pretty quickly for you, I'm sure. So good luck, and I hope it all goes smoothly for you.